Title 2, States and Indian Tribes. Application of the Title 3, U.S. State Code 1731. This is Section 201. The title shall apply with only respect to the oil and gas lease of the federal lands, the Indian lands. Nothing in this title shall be construed to apply with any of the lease of outer continental shelf. Section 202, the cooperative agreement. The Secretary authorizes the enter of the cooperative agreement, the agreement of the state with the Indian tribe of their share of oil and gas for management, information to carry out the inspection, auditing, investigation, enforcement, not include collection of the royalty, civil and criminal penalties, or other payment activities under this act with the cooperation of the Secretary to carry out the other activities described in Section 108 of this act, with the Secretary shall not enter into any of the cooperative agreement with the state with respect to the activities in Indian lands except with the permission of the Indian tribe involved. Except to provide in Section 203 of the presume of the cooperative agreement, each state head shall upon the request have the action of the royalty, accounting, information, possession of the Secretary requesting, respecting reproduction, removal, and sale of the oil of the gas from the lease of the federal lands within the state. Each of the Indian tribes shall upon the request have the action of the sale of the royalty, accounting, information, and the possession of the Secretary respecting the production, removal, and the sale of the oil or gas from the lease of the Indian lands under jurisdiction of such a tribe. Information should be available in paragraph 1 and 2, but as soon as practical after it comes in possession of the Secretary, effective for October 1st, 1983, such information should be made available to paragraphs 1 and 2 no later than 30 days after the information comes in possession of the Secretary. Information available to effective date. All right, you have Title 42.1 U.S. Code 501. No cooperative agreement entered in the pursuant of this section shall be in accordance with the provision of the Federal Grant Cooperative Agreement Act of 1977 shall contain such terms, conditions the Secretary deems appropriate with the consistent with the purposes of the Act, but not limited to with the limitation of the use of federal assistance to the costs and where directly required for the carry out of the agreed upon activities. All right, Section 203 was with the trade secrets, priority, and confidential information available to Title 30 U.S. Standard Code 1733. Section 203, trade secret proprietary with the confidential information shall be made available to the Secretary pursuant to the cooperative agreement with the state Indian tribe upon request upon only if such state Indian tribe consents to the written and restricted disseminating information to those who are directly involved with the audit investigation under this act who are needed to know. 2. Such a statement of the tribe except with liability for the wrongful disclosure in the case of the state, such for the state demonstrated that it has such information essential for the conduct of the audit and investigation and litigation under Section 204. In this case, of the Indian tribe has shall demonstrate that such information essential for the conduct of the audit with the investigation waiver the sovereign immunity by expressing consent wrongfully disclosure by such a tribe. Liability of the wrongful disclosure. The United States shall not be liable for the wrongful disclosure of any individual state and of the Indian tribe of the information for the provided with the individual state or Indian tribe pursuant to any of the cooperative agreement delegation authorized by this Act. Whenever an individual state of the Indian tribe has obtained the possession of information pursuant to the cooperative agreement authorized by this section, individual state has been obtained possession of information pursuant to the delegated under the Section 205 of the information subject to the same provision of the law with respect to the disclosure such information would apply an officer employed under the United States with any of the department agency thereof of the state with the Indian tribe shall be subject to the same provision of law with respect to the disclosure and such information which would apply with the United States to any of the department and agency of no state and the state officer employee who receives trade secrets proprietary information with confidential information under this act may be required to disclose such information under state law. State suits and under federal law. Title 30 U.S. Standard Code 1734, and this is Section 204A1. State may commence in civil action under the section against the person to recover royalty, interest, and civil penalty, which they believe it is due based on the credible evidence with respect to the oil and gas lease of the federal lands located within the state. 2A, no action commenced within the paragraph 1 prior to the 90 days after it has been given in written notice. Secretary of the payment requirement such 90-day limitation may be waived by the Secretary on a case-by-case basis. If within the 90-day period specified in subparagraph A, the Secretary is in demand for the payment of concern with no action may be commenced on paragraph 1 of the respect such payment during the 45-day period assistance after the issuance is such demanded. If during the 45-day period the Secretary received the payment in full with no action may be commenced on paragraph 1. The Secretary refers to the case of the Attorney General of the United States within the 45-day period of the referred with the subparagraph B within 10 business days after the expiration date of the 45 period. No action may be commenced after the paragraph 1. If the Attorney General within 45 days of such referral commences thereafter to diligently prosecute civil actions within court of the United States with respect to the payment concerned. All right, notification of the Secretary, Attorney, and the Attorney General. The state shall notify the Secretary and Attorney General of the United States that any suit filed by the state under this section, court issuing the final of the order, any action brought under the paragraph 1 of the most cause for the litigation include responsible attorney, the expert witness fee of any of the part of the touch of the act of the court determine the touch of the award is appropriate, and action brought with subsection A is may be brought with the United States District Court, Judicial District, which the lease site of the leasing activity complained of it's located with the such the district have the jurisdiction without regard to the amount of controversy with the citizenship of the parties to the require compliance with the order payment in such action. Notwithstanding any of the provisional law of the aim of the civil penalty required of the state under subsection A shall be retained by the state and may be expended in such a manner for the purpose of the state deemed appropriate. To any rent or royalty interest recovered of the state owned in the subsection A of the deposit of the Treasury of the United States for the same manner, some to the same requirements and as are applicable to the case of rent royalty interest collected by an officer employed with the United States, except for such amount shall be deposited for the Treasury no later than 10 days after the receipt of the state. Delegations to the state, Title 30, 1735, Section 205. Upon written request, any of the state secretary authorized delegate in accordance with the provision of the secretary, all parts of the authority responsibility of the secretary under this act conduct the inspection, audits, investigations to any of the states with respect to all the federal lands, Indian lands with the state, except for the secretary may be undertaken with the rights of the delegation with respect to any Indian lands, expect within the permission of the Indian land allotment involved the hearing. After notice opportunity for the hearing, the secretary is authorized delegated such authority responsibility granted under the section state has required the secretary to find that it is likely that the state and provide adequate resources to achieve the purpose of the act. The state has demonstrated it will effectively route faithfully administrative rules regulations of the secretary under this act in accordance with requirements of the subsection C and D of the section. Such delegation will not create an unreasonable burden over any of the lease with respect to the federal lands, Indian lands within the state. The Secretary shall promulgate regulations with the definement of those functions if any of them are carried out in order to avoid duplication effort of any delegation with the Union State may be made in accordance with those requirements. That was regulations with standards. Secretary shall shall rule, promulgate standard for the regulation pertaining to the authority's responsibility under the subsection A would include the standard regulation pertaining to the audit performed, records of account to be maintained, 3 reports, procedure for the required for the state under the section. Standard of the regulation should be designed to provide reasonable assurance that uniform and effectively royal management systems are prevailed among the state of the records and account with under paragraph 2 shall be sufficient to allow the secretary to monitor performance of any of the state under this section. Hearing. If any of the notice opportunity for the hearing of the Secretary of the Fine with any of the state without authority responsibility of the Secretary has delegated under the section violation any of the requirement of the section, any of the rule there that an affirmative adding of the Secretary under subsection B can no longer be made, the Secretary may revoke such delegation. The Secretary shall compensate any state with the cost if it may be necessary to carry out the delegated activities under the section. Payment shall be made no less than every quarter during the official year. Shared civil penalties, Title 30 U.S. Standard Code 1736, Section 206. Alright, Section 206 is an amount equal to 50% of the sum of any civil penalty collected with the federal government under this act resulting from the activities conducted with the state of the Indian tribe pursuant to the cooperation agreement under Section 202 or a state agreement under delegation under Section 205 shall be payable to such a state or tribe. Such amount shall be deducted for each of the compensation due to such state with the Indian tribe under Section 202 within such state under Section 205. Title 3, General Provisions, Secretarial Authority. Cut.